Welcome to the podcast Online Platforms, Competition Law and Regulation. We are hosting this talk ahead of the full-day event on transparency and non-discrimination requirements for online platforms. The symposium takes place on 6th of June in Brussels and is organized by Lexxion Publisher together with the law firm Shepherd Mullen. I'm Nelly Stratieva. I'm the executive editor of the European Competition and Regulatory Law Review, or simply the CoRe journal, as some of you might know it. We are happy to have several of the symposium speakers answering our questions today. I want to welcome Thomas Höppner. He is partner at the law firm Hausfeld here in Berlin. Hello, Thomas.
Hello.
Next, we have Jakob Kucharczyk. He is Vice President for Competition and EU Regulatory Policy at CCIA, Brussels. Hi, Jakob.
Hi there.
Then we have Ben van Rompuy, Assistant Professor of Competition Law at Leiden University and Vrije Universiteit, Brussels. Hi, Ben.
Hi, Nelly.
And last but definitely not least, we have Alexis Walckiers. He is Chief Economist at the Belgian Competition Authority. Hello, Alexis.
Hello. Hello.
Now, I want to take advantage of the fact that we have such a diverse group of experts here today. We have a lawyer from an international law firm, a representative of the tech industry lobby, an academic, and an economist working for a national competition authority. So let's start off with the big picture. What is, according to you, the biggest question concerning online markets on the competition law agenda this year? And why would you give this issue the top spot? Maybe we can start with Ben?
Sure. The biggest question for me personally would be to what extent self-preferencing by vertically integrated dominant platforms, so them giving preferential treatment to their own products and services vis-a-vis products and services offered by competitors, to what extent that self-preferencing can constitute an abuse of a dominant position. The European Commission pivoted this question or discussion with its Google shopping case, but without, however, spelling out the applicable legal test. And I also note that the view that self-preferencing constitutes a self-standing category of abuse was also endorsed by the special advisors to Commissioner Vestager in their recent report, and they even as the Commission emphasized that the preconditions of the essential facilities doctrines do not have to be met for this to apply. Now, this is quite a novel development in the law, the way I see it, where the principle of equal treatment, which we typically know from Article 106 case law, from telecom regulation, which only so far has been applied in a quite narrow context, where an obligation to deal, a non-discrimination obligation, was imposed on mostly legal monopolies having an input, whether a product, service, or infrastructure that was indispensable. But that principle now is applied in a broader context where apparently that indispensability criterion is no longer necessary. So what is the exact scope of this type of abuse? It's currently being explored in relation to online marketplaces, the Amazon investigation of the Commission, but also in Austria, Italy, and Germany, you have national cases, and in relation to app stores. And maybe with app stores you can see an indispensability condition, perhaps less so with marketplaces. So to me, the big question for the coming year, maybe after, is what is the exact scope of the special responsibility of dominant platforms to treat competitors equally?
Okay. Thanks, Ben. What about you, Jakob? What is your top issue for the year?
Yes. So obviously, what we see in this year is various competition policy reports that come out to tackle the question: how should competition policy look like in the future? How should competition law be applied to digital markets? Ben alluded to it. I guess first and foremost, we have the report of Commissioner Vestager's expert group that has laid out some of the thinking. Before that, we had a report from the UK. We expect another report from Germany towards the end of this year. Then currently we have countries like, for example, Spain, that do their own inquiry into this topic. So, all of these reports and the debates that are caused by these reports are rather broad, and I have to admit that I need to break our rules only once because I was not able to completely make up my mind about the one topic. So if you don't mind, I'll talk about two topics that I personally find extremely interesting. So the first one is access to data. And it is a topic that really seemingly never goes out of fashion. And it seems like it will also not go out of fashion in the year 2019. However, what's interesting is that there seems to be more of a nuanced debate. And the Commissioner Vestager's expert group raises some very interesting points about the difficulty of broad access to data obligations from two perspectives, really, and that's rather new in my opinion. The first one is technical. So, questions around what kind of data are we actually talking about, features quite prominently in the role. Then, of course, you have technical issues around how to protect data protection and privacy. Should you give wide data access, mandate wide data access? And last but certainly not least is the whole question about how to preserve the economic incentives for companies to engage in data collection in the first place. Now, all of these technical problems are accompanied by legal problems when it comes to data access, and there also I think we have a very interesting discussion around, for example, how would an obligation imposed on a company to grant access to its competitors, how would that play out under Article 102 under, for example, the existing doctrines like essential facilities? I think that's extremely interesting. Now, the second, and I'm going to keep this short, the second one, because that's something that is extremely close to my work, given that I also follow regulatory debates extremely closely in Brussels. And that is the whole issue of the interplay between regulation and competition enforcement. I think that what we see is increased attempts to resort to regulation where there's a perception that competition enforcement is maybe too complex or too ineffective or just too slow. And I think that the recent platform to business regulation that was passed in the European Parliament that basically regulates the business relationships that online platforms have with their business users is a very good example of that. And I would expect that kind of development to continue into the future. And that will certainly cause quite a debate in the future too.
Okay, thank you, Jakob. So we have so far on the biggest questions for the year: self-preferencing, access to data, regulation and competition enforcement. And what about you, Alexis? Where would your vote go for?
Well, basically, the good thing in not coordinating too much our debates is that I would very much agree with the first two speakers. And in particular, I had put, as my first point, the interaction between competition law and regulation. Because indeed, I would say that both this B2B platform regulation, the way it will be put in practice and the interaction with our practice as competition authorities will be really fascinating to see. So see how it develops and in which ways it goes. And I very much think that we are complements to each other. So that should bring a better outcome for consumers. And I would say that as the first speakers, privacy and data exchanges in particular have become more and more important. But I guess that what we are looking forward to, especially at EU level, I guess is the way in which competition investigations will be led. And I guess that there one of the main aspects will be the elections, the new commissioner, whether the new commission will be more political, whether in terms of merger enforcement, but that will have an effect definitely also on 101s and 102s, whether we go to more political decisions or whether we stick to more data-driven analysis.
All right. Thank you, Alexis. And Finally, Thomas, what does the lawyer think about the coming year? What is your biggest question that will be answered in 2019?
To me, the biggest question this year is whether the European Commission accepts the mechanisms that Google has rolled out to comply with the Commission's Google Shopping and the Android decisions. The Commission left it open to Google how to bring the identified abuses to an end, but many market participants believe that the measures we've seen so far are insufficient to seize the abuses. They argue that from an economic perspective, these mechanisms do not make any significant difference, as Google remains the sole beneficiary. And considering the character of the shopping and the Android cases as precedents, I think it is of utmost importance for the future of online markets that the Commission gets these two cases right and insists on compliant, effective solutions. Because while, of course, big fines have made great headlines, I believe it's more important now show that these decisions actually make a difference and impact on the market. And for that, I believe enforcing the remedies imposed in those will be a central task for this year.
Okay. So actually, I'm really happy with the conversation so far, because we have 4 different experts and you all gave different, or at least slightly different answers. So as you see, there's a lot happening in the world of EU competition law. Now, we've been talking about effective remedies in EU competition law for decades now, and definitely technological advancements and the new business models connected to them don't make things any easier. My second question would be, from your own angle, what do we need so we can come up with the golden formula for remedies in the digital era? Or do we have the formula already? Maybe we can start off with you, Jakob?
Yeah, pleasure. So to address your question, I think as a first point, I think we need to be careful with golden formulas or anything similar, because there obviously is a need for flexibility. It's well understood that antitrust cases are very fact-specific exercises, and for remedies to be effective and to make sense, they must be tailored to the specific case or to the specific conduct at hand. So for that reason, I also don't think that the way we conceptually think about a remedy has to change just because we have a case in the digital economy or a case that involves a digital player. Whatever the digital economy might mean, in the world where our economies increasingly become digital, of course. But I think going back to the very concept of a remedy, I think it's worthwhile to recall that one can make a basic distinction between what some have called reactive and proactive remedies. So you probably know that reactive remedies are pretty straightforward. It's your traditional remedy that would, for example, order a firm to refrain from engaging in conduct that has been found to be an infringement. So it's your stop it remedy, right? For example, if a competition authority ordering companies engaged in cartel to stop the behavior would be a good example here. But then you have the second kind of remedies that are proactive, and these are very often more sophisticated, as they might take different forms depending on the circumstance of the case. And so, you might have a remedy that will proactively order a company to give access to an asset or even alter the design of its product. Now, I think what is true for any industry, digital or not digital, is that it's important to realize that proactive remedies or regulatory remedies, as they are also called, are much more complex than a simple negative obligation to stop a behavior. So I think that my point would be that competition authorities are and very much should be aware of that when running the cases, because for obvious reasons it is quite important to think carefully about how a company would actually be able to implement a remedy in practical terms. So I think I'll leave it at there.
Okay. So we have industry appealing for more flexibility in the formula for remedies. What about national competition authorities? Alexis, what is your view?
Well, I would very much agree with what Jakob said. First of all, I don't think that there is a golden formula. And second, as he said, online markets are not as such very different from other markets. And I think that, appropriate remedies appropriately remedy an issue or a theory of harm. And it's important to start with defining, well, what is our theory of harm? And that can only be done on a case-by-case basis, because there are many different issues in the online markets. And one speaks about the GAFAs and others, but all of these companies have a specific business model. And I think that it's important to understand what is the business model, what are the eventual problems that you want to remedy, and this should be a start to better understand how you can address the problem through a remedy. And so basically, the bottom line is a little bit like Jakob said, on a case, we should start with a case-by-case analysis.
Thank you. What is your opinion about remedies in the digital era?
I agree with the previous two speakers that there is no golden formula yet, and in general, the same rules should apply whether it's an offline or an online world case. However, I believe that two issues are important as they are specific for online markets. Firstly, in order to find workable remedies in the digital area, I think we have to focus more on the element of network effects, as they are characteristic for competition in this area. If a market has tipped as a result of an anti-competitive conduct that has been triggered by unjustified positive network effect, it is simply not enough to then ask the by now dominant platform to stop its conduct. This will simply be too little and too late. Rather, to the extent that an anti-competitive conduct has generated such positive network effects for the now dominant platform, I think effective remedies have to outbalance these unjustified effects. And it is against this background that it may be that an infringing company may have to be obliged to actually proactively share any competitive advantages that it has secured through its illegal conduct. For instance, by sharing the data that it has gathered, or by granting rivals the same preferential visibility or any traffic that it has enjoyed as a result of the infringement. The second point is that I think we have to look closer at the typical behavior of consumers online. It makes little sense, for instance, to try to remedy an abuse by offering consumers any choices or any additional information if they do not understand, do not care, or even find that information burdensome, and therefore will not use that in any way to actually foster competition. So taking into consideration the network elements and the actual consumer behavior online, I think are two crucial elements to find a more efficient formula to remedy anti-competitive conduct online.
Thank you, Thomas. So we seem to have a consensus that there is no single golden formula, but we should have flexibility in it. But now the last opinion that Thomas shared was that we have to be beware of the network effects and the behavior of consumers, and that should also be taken into account when we speak about effective remedies. Ben, do you agree with that, or do you have a different point of view?
No, I absolutely agree. Designing behavioral remedies is always challenging. I also agree with what Alexis said, that in many regards, online, offline markets are quite similar. It's always a challenge, but I also concur with what Thomas just has said, that what is different perhaps in the online world is the quickness, the swiftness with which you might want to intervene. There's little point to intervene after many years when a market indeed has tipped. So in that sense, yes. I mean, it's always challenging taking behavioral economics, consumer behavior into account, absolutely. But then I would also suggest that we should look into manners or into options for more speedy and swift remedial action. So the European Commission, for example, has never used interim measures since the entry into force of Regulation 1/2003. That is so because the case law has set a quite high burden, and that's really a constraining factor. And the alternative would seems to be to make use of commitment decisions. Well, if you look at the Google cases, that hasn't really resulted in a quicker result. So at the national level, and Alexis can testify to that, we do see a lot more interim measures being imposed by competition authorities. So for me, I think it's worthwhile exploring whether the European Commission as well should, be it in a limited number of circumstances, in emergency situations, actually impose interim remedies to preserve the status quo and prevent having to do too little too late, as already has been mentioned.
Okay, so
I'm happy to confirm. If I don't know whether it is the idea that we react to each other's speech, but basically, indeed, we do have quite a couple of interim measures imposed every year. I don't know though whether online markets, which are fast-moving, are the best examples of sectors in which you would like to set interim measures, because one of the issues obviously is to get some legal certainty, and to be sure that you get legal certainty. In some cases, you need to have a more thorough analysis of the facts in the at hand.
thank you for the response, Alexis. I think we have to keep the discussion a little bit more structured, and we wait for the bigger debate during the event in Brussels. I want to take you to a more general question again, because we've heard so far from you what we should be doing in EU competition law, or maybe what we should be doing better. But how about what we shouldn't be doing? So I want to ask you, what are some of the perceived issues with online platforms that competition law should not tackle? Alexis, could you start off?
With pleasure, thanks. Well, I think in principle there are not a lot of things that we should not do. But indeed, beyond this principle, coming back, for instance, to what was discussed earlier on the interaction between regulation and competition, I think that it is wise for a number of these questions to let regulation authorities work out what the judicial the system asks them to do. And so I guess that I see this interaction between regulation and competition as being more of a complementary nature than of a substitute nature. So there is no reason that we shouldn't be able to work together. But I think that they should first use their tools before we competition authorities can see how we can complement the way they work.
All right. So being careful with the use of regulation. How about you, Thomas? What do you think? What should competition law not do?
I think there are several issues, online platforms, that are currently discussed in the context of general competition law that should probably better be dealt with under specific legislation. Data protection, privacy, media diversity, and transparency concerns are just a few examples. I think it is understandable that it is tried to use more general competition law provisions to address such specific concerns in the current absence of sufficient specific legislation. Basically, the Internet has grown too quickly and the legislators haven't caught up yet. However, there is a risk that such approach using general competition law may actually overstretch the very limits of competition law and thereby, unfortunately, weaken it. And that is also with a view to traditional competition law cases in particular, there is a risk that by adopting concepts from more specific, let's say, data protection fields into general competition law, the actual lines of competition law, the lines of what is allowed and what is not allowed, are blurred, and that creates some legal uncertainty, which in other cases is then not particularly helpful. So I think while for some time it is understandable that competition law is used to fill in loops, I think the better approach would be to try to find more specific legislation to address these issues.
All right. So making sure that there is a divide between competition law and data protection law. We are seeing more and more of these cases coming up lately. Ben, what do you think? What should competition law limit itself to?
I very much agree with what has been said. I mean, competition law should address competition problems, but they do come in many flavors. So in principle, no limits. We also have seen that competition law in the past has often been a testing ground or a first mover, after which regulation was adopted. Think about roaming, think about network unbundling in the energy sector. It often was competition law cases that started it all. That said, I find actually, and I've given it a lot of thought, but I find indeed what Thomas also mentioned, data protection, to be a strange one, because there we have legislation, and maybe it's insufficient, but then we should fix that. We have the new GDPR. So this is the other, the same trend, but the other way around, where what the Bundeskartellamt has done in the Facebook decision, I still don't understand what the added value is of competition law in that context. You can establish a GDPR violation. Why do you then have to add the extra element to it that it is also a 102 infringement? So that's very odd. If it was to fill a void, I can understand. We have used competition law in the past to fill regulatory voids. But if you have a regulatory instrument, then I don't see the added value of using competition law to address that problem, which is better addressed by specific regulation, which we actually have.
Thank you, Ben. Now, Jakob, I want to turn to you, and I realize that you have a difficult role speaking for industry here, especially since it's so hard to have a unified voice for industry. But can you share your opinion what competition law should not tackle?
Yes, sure. And I think actually our opinion is really not really divided, if you like, because I think that one could answer this question totally independently of any perceived issues with online platforms. Because at the end of the day, I think it's very much a question about the raison d'être of competition rules, if you like, right? So why do we have them in the first place, and what should be their aim? And frankly speaking, I think I'll provide a very unspectacular answer here, which is that I'm convinced that competition rules and competition enforcement more generally should very much be about protecting the process of competition in order to maximize consumer welfare. I mean, that's your textbook explanation, if you like, and it's very much in line with what our European courts have repeatedly said in cases. So I believe that fundamentally protecting the competitive process must necessarily be grounded in economic theory, but also in business reality. And in light of this, I would like to echo many of the things that have been said before me, indeed, particularly the need to maintain clear dividing lines with other areas of the law. I think it's true that we see a trend where there is a lot of pressure of competition policy to absorb ever more concerns, ranging from social inequality, if you like, to data protection. And as such, I think that it's, as a general rule, competition law should very much stay clear of policy issues. It has neither been designed for nor tasked with. Else we would risk conflicts of law. And for businesses, what that basically means for us, for our industry, is increased legal certainty. And maybe a last point I would like to raise in this context is the need to avoid political interference with the substantive analysis of cases. be those in antitrust or in merger cases. I think that the more politics we allow into the system, the less predictable and legitimate the system will ultimately become, and I think that would obviously undermine our enforcement more broadly speaking.
Thank you, Jakob. I think the four of you gave our listeners a lot of food for thought, almost ranging to the philosophical role of competition law in the single market, especially in the digital single market. Perhaps to wrap up this podcast, one final quick question to all of you. In one sentence, exactly 1 month before the event in Brussels, what are your expectations of the symposium? Thomas?
Well, listening to the great points my colleague speakers just made, I'm very optimistic that the symposium will provide a great forum to exchange views on current developments in the area of digital markets.
Ben?
I very much look forward to getting critical insights on the upcoming platform-to-business regulation, particularly its enforcement mechanism, and to the very practical case-oriented discussion about my big question, which I raised, the lawfulness of self-preferencing under EU competition.
Thank you. Jakob, one sentence from you. What are your expectations of the symposium?
Yeah, my expectations are to continue this exciting debate, to learn from others' points of view, and to explain how we as technology industry view the various issues that are currently hotly debated across the globe, really.
And finally, Alexis, what are your expectations?
Well, I would agree with most of what I have heard here. I very much look forward to continue this discussion. It was very insightful. Thanks.
And on that note, I want to finish the discussion today. A big thank you to all four of you for sharing your opinion with our listeners. I'm sure that we have a lot more interesting questions to discuss during the symposium. So join us on the 6th of June in Brussels for the symposium Transparency and Non-Discrimination Requirements for Online Platforms. You can go to Lexxion's page at lexxion.eu. There you can check out the full program and book your seat. Thank you for listening and see you in Brussels.